Good afternoon and welcome. My name's Jim Park and I'm one of the faculty directors of the Lowell Milken Institute for Business Law and Policy at UCLA School of Law. This is the first panel of our COVID-19 in Business Law Conference organized by Joel Fewer, Jason O, and myself. The title of the panel is Should Boards Owe Duties to Stakeholders? Lessons from the COVID-19 Crisis. Even before the pandemic, there was renewed interest in challenging the focus of corporations on increasing shareholder wealth. The COVID-19 crisis has raised a variety of questions about both the shareholder wealth and stakeholderism approaches. The panel is particularly timely because this week marks the 50th anniversary of the publication of Chicago economist Milton Friedman's article declaring that the social responsibility of business is to increase profits. I will briefly introduce our three distinguished panelists. Our colleague Steve Bainbridge is the William Warren Professor of Law at UCLA School of Law and is a leading expert on corporate law and governance. Jeffrey Lipshaw is a professor at Suffolk University of Law and the author of a recent article that argues that the shareholder versus stakeholder debate represents a false dichotomy. David Katz is a partner at Wachtell, Lipton, Rosen & Katz and writes frequently on corporate governance for publications including the New York Law Journal. I'll now turn things over to my co-moderator and UCLA Law colleague, Iman Anatawi.
Thank you, Jim, and welcome everyone. I'd like to start off really with a nod to the title of today's conference, and that is Should Boards Have Duties to Stakeholders? It occurred to me that when we ask about whether boards should have duties to stakeholders, there's a legal aspect, a legal dimension to that question, whether legally boards owe duties to stakeholders. And there's a policy dimension to that question, namely within the zone of the discretion that they have under the law, should boards owe duty to shareholders? Should they use their discretion, irrespective of what the law's aspirations are for them? Should they use the discretion that they're given under the law to support stakeholders? So with that distinction in mind, but giving you full leave to restructure the question, I would like to begin by asking each of our panelists to describe their positions, their individual positions on the question whether boards should owe duties to corporate stakeholders other than shareholders. And we thought we'd start with Steve Bainbridge and then go to Jeff, then David. So Steve, please go ahead and get us started.
Okay, thank you, Iman. Well, as to the legal question, you have in your MCLE materials the sort of dueling articles that Jeff and I wrote over the last summer on some of these issues. And to very briefly summarize my take on it, I think that there is no duty under current law for directors to consider interests of corporate stakeholders other than shareholders. And I think, in fact, to the contrary, the law says very clearly that directors who do consider such interests are violating their fiduciary duty of loyalty to the shareholders. And Jeff, I think, can probably predict what I'm about to say next, because you don't have to take my word for it. You can take the word of former Delaware Chief Justice Leo Strine, who, despite his what some people would think was his surprising op-ed piece in the New York Times recently, has been very clear on the is question. He says, within the limits of their discretion, directors must make stockholder welfare their sole end, and that other interests may be taken into consideration only as a means of promoting stockholder welfare. As for whether the law ought to allow directors to consider these questions, that's an extremely complicated question, as we all know. Whole forests have been devastated in the literature on this. Suffice it to say that I think that on balance, the core problem here is that once you let directors start considering interests other than the shareholders, then you have the problem that directors will favor whatever stakeholder interest best matches up to their own interests. So that if a particular decision benefits the directors will say, well, we're making this decision because it benefits employees. If a different decision benefits the directors, they'll say, well, we're making this decision because it benefits shareholders. And the bottom line is the directors who are accountable to everyone are accountable to no one. I think that's enough on that point.
I guess it's to me. So my simple answer to Iman's question is no, just like Steve's, although to be clear, I am only concurring in the result. Usually in my introductions, Jim, I'm going to do a little bit of your work here. It's pointed out that even though I've been an academic for 15 years, before that, for 26 years, I was a lawyer in the real world, and indeed was the general counsel of a public company. And so I actually sat in and watched what directors did for the better part of 6 years and talked to them about it. And so I think the answer, the more nuanced answer, is that as a matter of corporate law, indeed boards have almost unlimited discretion for all intents and purposes to take care of stakeholders as long as boards can articulate. I'm not even sure it has to be rational. As long as they can articulate a connection between what they do and some benefit to the corporate enterprise. And I think I'm less willing than Steve to think that as a matter of law, that there is some duty to maximize shareholder wealth existing out there as kind of a, I don't know, disconnected metaphysical truth. And I suppose that my views as a jurisprude come into play here, which is, my view is that what law is comes from the application of rules to real factual situations, not, as I said extensively in the article, abstract and generalized platitudes. So when the rubber hits the road, the business judgment rule is going to be the operative one in all but the most idiosyncratic cases. And again, to put a plug in for Steve's hypothetical, the most extreme hypotheticals of zero-sum conflict between the shareholders and some other constituency, or in the really odd cases where a CEO has publicly said, probably to the chagrin of his lawyers or her lawyers, expletive deleted the shareholders. So, you know, my view is that in ordinary circumstances, good management or good leadership may well appear to favor at a particular moment non-shareholder stakeholder interests over the shareholders, and hence the debate tends to be, again, one of dueling platitudes. But having said that, again, like Steve, I see no need for the corporate law as an institution to protect stakeholders. And I think this goes back to part of Iman's question. There really are a lot of other market, political, and legal institutions already doing that. But even to look at the law and look at it through lawyer-tinted glasses, in terms of the employee stakeholders, there are fair employment laws, there's the NLRA, there are minimum wage laws. For communities, there are environmental laws, there's the WARN Act if you shut down a plant. And indeed, to take hypothetical megacorp, if they have a factory in Ohio and Ohio wants the employees to share more in the corporate trough, well, let Ohio pass a law. Don't send them to Delaware and ask the Chancery Court to regulate it.
Thank
I think
you. What are you telling your clients? Can they follow their moral compass? Maybe you can address that as part of your answer.
I think we're in a very interesting time right now, and the COVID-19 debate is part of what's going on. I think that in Delaware, I would say Steve is correct as to what the letter of the law is. And Jeff, by agreeing with him on what the corporate law is, I do think, though, that in a number of other jurisdictions, the decision's already been made because there are constituency statutes in place. And some of them say may, which gives the board broad authority to consider those other interests. There's one or two statutes that say shall, which would arguably force a board to consider those interests. At the end of the day, my biggest concern is if we focus solely on shareholder returns, especially in the shorter term, I think we're going to end up in a system that's much more regulated, because we're going to have either the federal government or state governments weighing in on the particular issues that may be of the moment. As Jeff sort of said at the end, if Ohio wants to do a law, they can do a law. Well, every time Ohio does a law or another state does a law, or somebody switches jurisdictions to get the benefit of a law, you know, the system sort of works because people do that, but there's tremendous cost to doing that. And I think in a lot of the situations, the debate is basically made for the directors. I mean, when we had COVID-19 and you know, the president asked certain companies to switch over to ventilators instead of cars, you know, that may have been a money-losing proposition, because now there's a shortage of cars when a lot of people want to go out and buy new cars. You know, but at the end of the day, almost all of the companies that were contacted did, you know, pick up and work under that situation. They didn't try to argue with it. Their shareholders didn't, many of them didn't like it, but understood it. But you know, in the court of public opinion, the corporations were seen as doing the right thing under those circumstances. Directors really do worry about these issues much more today than they used to. I'd like to think it's because people are writing on it more and really calling people's minds into questions about exactly what happens. But, you know, I think, Steve, to your point, if any board of directors is making a decision because it benefits them at the end of the day, no matter what excuse they give to it, that's clearly a violation of the duty of loyalty. No ifs, ands, or buts about it. The question really becomes, though, if they get information and they think, well, longer term, if we give higher wages to our employees or take better care of our employees, are we going to have better returns for the shareholders? That's a common question. You could focus it just on the employees, or you can draw a conclusion that in the end of the day, you're benefiting the shareholders over the longer term because you're going to have happier employees, they'll be more productive, et cetera. And so, you know, you've got to look at the particular situation. If you look at it very short term, I think you look at the constituency and decide whether you're going to favor that constituency. If you try to look at it over the longer term, in many situations, the story that you're telling is, in the short term, it may have a cost for us, but in the long term, we expect it to be a better, stronger corporation. We expect it to have better returns. Delaware has given us the gift of the public benefit company, which we are slowly starting to see some companies take that at issue. That's clearly an alternative choice. And, you know, it's going to be interesting to see whether we do have some major corporations going toward that end. Right now, there are some public companies that have selected it, but they've done it in connection with their IPOs. We do know that from some of our clients, there are some public companies that are thinking today about switching, which would require a vote of their shareholders. But it will be interesting to see how that comes out and whether the shareholders are actually going to support the change.
Before moving to the next question, I wanted to see if Steve or Jeff, did you have any response to anything any of the panelists have said?
I sort of wanted to pile on to something that David was saying and just give some personal experience. I was the general counsel of a chemical company based in Indianapolis. And so two aspects of David's comments. First of all, if you've ever tried to recruit a significant employee to Indianapolis, you start to ask the question, you know, why should I go there? And to put this in the frame of the Bainbridge hypothetical, if we've got $100,000, should we return it to the shareholders or should we make a contribution to the Children's Museum? And the board, I'm not even sure it gets to the board, but management certainly will make the decision, or may well make the decision. We're going to support the symphony and we're going to support the Children's Museum and the Art Museum because we have an interest in the long term of benefiting the corporate enterprise, and we only do that by recruiting people who want to be, or recruiting people to a place they want to be. Also, and then again, with respect to what the directors do and think about, again, we were a chemical company, and it was entirely possible that if you took the most aggressive safety stance on chemicals out there in the world, that you could fight tooth and nail and probably make more money producing a chemical that had a high profit margin, but ultimately had questionable long-term effects. And I can tell you our management all the time considered that somewhere short of the extreme. And I don't know, where that fits into a legal rule or a legal algorithm about maximizing shareholder wealth. What it says to me is that operating a company is incredibly complex, and that ultimately, in looking out for the enterprise, you are looking at lots of dials and lots of meters.
Let me start by saying that I agree with much of what Jeff and David have said. And if you know my scholarship on what I call director primacy, or you've read, for example, my article on the business judgment rule as an abstention doctrine, there is no one, I think it's fair to say, there is no one in the legal academy who has been a stronger defender of the board of directors' discretionary authority. That has been a bedrock of my scholarship. Where I think if you read the articles that Jeff and I wrote this summer, where we, I think at the end of the day, disagree is how important of a problem is the zero-sum situation. I would certainly agree that the vast majority of business decisions are not zero-sum decisions. And in those cases, the board of directors should have all the sort of discretionary authority that David and Jeff are talking about, that the board should be able to think about the long term. And we don't want to second guess boards in that situation. Where David and I, where Jeff and I differed was, I think there are zero-sum decisions. And I think those are the interesting decisions, right? Those are the sort of theoretically, academically interesting decisions. And even if they don't come up very often, it's helpful to know what the law in that area is. Back to you, Jim.
Thank you, Steve. If I might ask Jeff, could you describe the Bainbridge hypothetical very briefly for the audience members who may not be familiar with it? Or actually, maybe Steve should do it. Actually, Steve may be a better describer.
You want me to do it? Wait. Do you want me to do it?
I'll do it.
No good lawyer would let that happen.
The Bainbridge hypothetical goes something like this. The board of directors is faced with a decision about whether or not to close a particular plant. And it's a zero-sum decision. The plant either gets closed, in which case a lot of stakeholders lose jobs, et cetera, et cetera, et cetera. Or they close, or they keep the plant open at great expense, yada, yada. What should the directors do in that situation? They don't have a choice, right? They have to decide. And the real world example I used for this was the Carrier Corporation's decision back in 2016 when Donald Trump was standing in front of their factory and complaining about their plans on moving the factory out of the country. The board has to make a decision. Do we keep the plant open? Do we close the plant? And if the board is accountable to shareholder interests in the hypothetical, that means they close the plant and relocate it. A board that's thinking about stakeholder interests keeps the plant open, even though that's costly for the shareholders. And a board that's accountable to no one is going to make the decision that's in their best personal interest, right? That's the gist.
Thanks, Steve. Before Jeff and David, you can comment on your thoughts on the hypothetical, but I'll add another question into the mix. As you know, the Business Roundtable about a year ago issued a statement expressing a fundamental commitment to corporate stakeholders. What's the meaning of this statement? Is it something that you think will have an impact? Was the corporate response to the pandemic consistent with that statement? I might ask David to begin with that if he's so inclined.
It's a very good question because, to begin with, they're words on a page, and unless directors really take them into account in their decision making, nothing's going to happen. And I do believe that directors are starting to take some of that into account. There's also situations where directors weren't consulted in some cases before companies signed on to the Business Roundtable and have reacted in some cases negatively to that approach. But in the current situation, I think that it's you can either say it's a very easy decision or a very difficult decision. If you allow your employees to work from home, even though they're assume that they're less productive, but it's safer, and the idea is that it may cost you a little more because they're less productive, but they're working at home. Are you doing that because you like your employees, or are you doing that because the government's told you to do that, or are you doing that because the idea is that when things turn around, you're going to have the healthiest group of employees and they'll all come back to work and be more productive? And depending on how you view it, you're going to draw different conclusions about whose interest they're taking on. I mean, a good example that I talk about to sort of contrast with Steve's when I'm teaching on this court topic is you've got an oil company that is going to build a new well in some small place in Nevada. They, out of the goodness of their hearts, put in a brand new fire station that serves all of the residents of that little state land holding. So it's not just theirs, it's a public thing, but they fund it, they buy a fire truck, they do all these things for it. One can say, well, that's a corporate contribution to the community. Or one can say they're actually looking out for their own welfare because if, God forbid, there's a fire, you now have a fire department that could go and answer it. That sort of shows the dichotomy of some of these decisions, because if you try to look at them in the initial short term, you wouldn't make them. But if you actually look at what the purpose is over a longer term, I believe that directors will. My biggest fear, though, is if we refuse to take into account this interest of stakeholders, and frankly, we every day companies take into account the interest of stakeholders. If somebody dies from a drug that is used and they recall the drug, even though only one person died, but it might help millions of people, is that a stakeholder decision or is that a shareholder decision? And some of those answers get taken out of their hands. The FDA may force a recall or something along those lines. My big fear is that you are going to end up with either the federal government or perhaps states trying to meddle into the stakeholder debate in a way that would be very difficult and problematic for companies to do what they do best and come out with the best result, and at the same time fulfill whatever the legislated need is. Legislation is messy. It doesn't get at the problem. Self-ordering, which I think a lot of people did during the COVID crisis, I think has worked reasonably well. Is it perfect? No. But in a lot of situations, you don't have to put the legislation in to get companies to do the right thing. Jeff?
Yeah, I actually started in on the article that ended up with Steve's and my debate over the summer before the COVID crisis hit, because the Business Roundtable issued the statement, and Steve, whose blog I read religiously, immediately reacted as I expected he would, as did the right-hand side of the Wall Street Journal op-ed page, as did the Council of Institutional Investors. And you had all of the usual reactions. You had Andrew Ross Sorkin in the New York Times saying it's about time, and Elizabeth Warren and so on. And my reaction, again, I have to say, based on my own experience, I mean, the primary problem our board had was it was 9 65-year-old white guys. But beyond that, I think that they did. I watched them act for 6 years and watched them take decisions into account and tried to be responsible. And so my reaction was, it's a nothing burger, in the sense of, yeah, they're still saying we're looking out for the shareholders, but we have all of these other commitments. So long before COVID hit, my conceit in the article was to go back before the Business Roundtable and just take a sampling of 100 CEO letters to shareholders and annual reports, and count the number of times that CEOs, and perhaps it's just rhetoric, actually said in those letters, we have a commitment to some stakeholder other than the shareholders. And we took 100 of them. We took 33 of the signatories. We could only find 4 Business Roundtable companies that didn't sign. So we took a sampling of another 67 New York Stock Exchange and NASDAQ companies. And we looked at it, and what we came up with was that indeed, to a greater or lesser, but largely to a greater extent, CEOs were talking about their commitments to the constituencies of their enterprise, in addition to their shareholders, long before the Business Roundtable statement went out. And so once COVID hit, we said, okay, let's take a look at the same set of 100 companies and see what they're saying now. And so we did, again, a quick survey of the 100 companies. Of the 100 companies, 98 companies mentioned COVID either in their first earnings release for the first quarter or in another communication. 83 companies of the 100 that we looked at, and again, I'm not making any claim for statistical significance, but 83 companies stated explicitly that health and safety of the employees or customers was the highest or first or primary priority of the company. Only 3 companies out of the 100 actually talked about shareholder value and didn't mention COVID. But we didn't see a single communication in which the CEO was saying, or the company was saying, that our highest priority continued to be the maximization in the short term of shareholder wealth. So again, I think that for whatever reason that management or companies do it, whether it's long-term goodwill or it's, and I'll get academic here. I don't know whether it's utilitarian and consequential. They're doing it because it helps them in the long run. I don't know if it's deontological. They're doing it just because they think it's the right thing. But it seems to me that's the way it happens.
I've discovered a wonderful new phrase. It's called woke washing, which is where you scrub up your corporate governance to make it appear that you're very woke. There's an alternative phrase that's going around, go woke, go broke. But I think the BRT statement was just woke washing. I don't think it changed very much. And Lucian Bebchuk has looked at this and found that it looks like a majority of the CEOs didn't get board approval to sign the statement. Remember that the Business Roundtable is an association of CEOs. And he also found that virtually none of the signatories have changed their corporate governance guidelines to be in accord with the Business Roundtable statement. And there's evidence that CEOs, in fact, don't walk the walk. The first piece of which is just anecdotal, but it's too good of an anecdote to pass up. In late August, shortly days after the Business Roundtable statement was made. The Wall Street Journal reported, quote, "One day after Salesforce.com posted record quarterly sales, the business software company notified its 54,000 person workforce that 1,000 employees would lose their jobs later that year." This is, of course, before COVID-19 emerged. I don't even think Scrooge would have told his employees, by the way, 2% of you are going to lose your jobs in a couple of months down the road when I get around to it. And what I think makes this such a powerful anecdote is that Salesforce CEO Mark Benioff is one of our leading social justice warrior CEOs. I mean, he's the one that's out there. I'll quote from him in the New York Times about Milton Friedman. "I didn't agree with Friedman then, and the decades since have only exposed his myopia. It's time for a new kind of capitalism, which recognizes that our companies have a responsibility to shareholders, but also our employees, except for the 2% I'm going to fire later on." And more broadly, there's a study that was noted in the Wall Street Journal by a couple of economists. Do the socially responsible walk the talk, which looked at business roundtable signatories of the statement and found that by and large they had worse records with respect to labor and environmental issues than non-signatory comparable companies. So it's woke washing. That's all it is. Jim or Ahmad?
I'd like to direct this question initially to David, and then let's follow after that with Steve. The thing that I want to focus on at this point is the difference between maybe shareholder value and shareholder profit, or shareholder welfare and shareholder profit. Recently, a group of 322 long-term institutional investors with over $9 trillion in assets under management issued an investor statement on coronavirus response. And they asked corporations to take a variety of steps, including providing paid leave to employees, taking measures to maintain employment, and exhibiting financial prudence by suspending share buybacks. So if shareholders themselves are pushing for greater attention to employee interests and are signaling that they value these measures, should boards respond by taking them into consideration and be directing their efforts at maximizing shareholder welfare, or should they continue to narrowly focus on shareholder profit? And then Jeff, why don't you finish us off after the others start?
It's a very interesting question. I think that, you know, on the question of accountability, you ignore your shareholders at your peril. And the key question, and it's, you know, the CII sort of took the focus away from individual institutions. I think it's problematic for them to issue a statement like BlackRock does, or State Street does, or Vanguard does, and a few others do. But, you know, if you're hearing this as a director and you understand the issues and you're asked to make a decision, do I do bucket A or do I do bucket B? You know, what's the impact going to be on the employees? Is it wise? Is it a good business decision? Is there something else going on? I think by and large, companies have tried to follow the paths that the institutional investors have asked them to take. What really matters, though, is when these companies have dialogues with the institutional investors, are they going to be criticized by one part of the institution and lauded by another part? And it's very interesting because a lot of these entities have now put forward ESG committees or ESG testing types where they want to meet with the companies and hear from them. But at the same time, those people who make those decisions and decide whether or not the company's doing a good job are not the people that make the decisions about whether to buy or sell the securities of that company. And to my mind, until you sort of meld those two together so that the buying and selling decision takes into account some of these other aspects, you're really not going to get a clear answer, because if the company's responsive, but it loses money and gets sold, it has the shares sold, is that really supporting the end that the institutional investors talk about? It is a very difficult issue. I will tell you that companies that are having directors go and meet with institutional investors and talk about some of these issues are getting a pretty warm reception. Companies that are ignoring their institutional investors and not engaging on this are having a much more difficult time. But I think that, whether they actually get called on the carpet because they don't respond to Larry Fink's letter or the State Street letter or something along those lines, that usually is not the decision maker at the end of the day. Jeff?
So back again, I'm going to harken back to my days back in the real world. One of my jobs was to respond to shareholder 14A8 proposals. And if you go on to Edgar and you take a look at some of the old Great Lakes responses, I think they sing, but you can draw your own conclusion. Indeed, I think there was one point at which I had Nell Minow on my speed dial. And it was in the heyday of shareholder resolutions on poison pills and classified boards. And I can tell you that there are institutional investors and there are institutional investors. So when the Longview Fund of the Amalgamated Bank or the AFSCME Pension Fund or the Comptroller of the City of New York was filing a shareholder resolution, it either was some political statement or it was another way of trying to get some of the corporate surplus into the hands of their constituents. Indeed, my cynical view, and probably I'm aligned with Steve, I think I may be aligned with Steve on this one because I think Steve has written at least something in the blogs about this. It was great because if you were a union pension fund, you had management coming and going. You had them coming as employees and you had them going as shareholders. So I'm cynical about that. On the other hand, when BlackRock and Vanguard and State Street start putting it on their agenda, as I assume they are, I'm sorry, but I can't believe they're doing it just for eleemosynary benefit, and that there isn't some long-term strategy. And I go back to something David said in one of his comments. Maybe they're looking at the long term and thinking that as part of their own marketing or their own survival, radical income distribution is a bad thing. I just know, or like Henry Ford, I'm putting in a $5 day because I want my employees to buy my product. I'm hard pressed to second guess their own business decision. I can tell you again, there was one point at which Geico, which is part of Berkshire Hathaway, owned 14.8% of our company, just below the 15% cutoff on the poison pill. And if they had something to say, we listened. And I think that that's probably true now as well.
Thank you.
Let me start by saying that woke washing exists because it looks like there's a demand for it. There's actually survey data that millennials and Generation Z individuals as customers prefer to purchase from companies that project an image as social justice activists. There's evidence that they prefer to invest with companies that project such an image. Nike's decision to have Colin Kaepernick lead its advertising campaign is perhaps the best known example. And what's interesting to me is that anecdotally, talking to my students in advanced business law classes, not a bar class like business associations, but an advanced class like mergers and acquisitions, talking to students who hope to go work for big law firms like Wachtell Lipton and practice sophisticated M&A work or corporate finance work, have much more of a sort of, progressive worldview than they did 15, 20 years ago. Now, granted, that's at UCLA, but I think it speaks to the idea that there is a market for that sort of thing. Now, the problem is again, is it a real commitment or is it woke washing? And if we look at BlackRock, Vanguard, and State Street, I'm not convinced that it's anything more than woke washing, with the possible exception of State Street. BlackRock talks a lot about ESG issues, and certainly Larry Fink's letters to CEOs are infamous or famous, depending on your point of view. But the bottom line is that neither BlackRock nor Vanguard, nor really even State Street, devote substantial amounts of personnel and resources to monitoring ESG issues at their portfolio companies. And there's significant evidence to suggest that despite the fact that they collectively, just those three, own enough shares to swing the vote on things like ESG shareholder proposals under 14A8, they rarely vote in favor of such proposals. And that they are essentially, as voters, passive. So I agree with, I think it was David who said, when the institutional investors start making decisions about what companies to invest in, and insert bracket here, there's another conversation to be had about how they do that in the context of indexing, but that's for another day. But until the institutional investors start actually investing and voting along ESG lines, I think that we don't take this sort of statement that Aman cited as being much more than puffery. Aman?
I'll jump in here with another question. The pandemic highlighted the vulnerability of our healthcare system, given that much of our manufacturing base has been outsourced and is now overseas. Is this evidence that a focus on shareholder wealth generation is problematic from a broader policy perspective?
Well, if I can start off, I don't think it's Ford's responsibility to think about whether or not they need to stockpile ventilators in case there's a global pandemic. I think that the COVID-19 response represented a series of failures of government policy over at least a 2-decade period. We've known that zoonotic diseases face or pose a considerable risk, at least since the AIDS epidemic began. And my God, how many bad movies and bad thriller novels were written about Ebola epidemics. And Ebola did look like a nightmare that was waiting to happen. And over the years, there have been many public policy proposals for governments to prepare for pandemics. At least here in the United States, those proposals have either never been funded, they've been underfunded, or they were defunded. And to some extent, it's like Leo Strine used to say, you want directors to maximize shareholder wealth, but to do so within the boundaries of the law. And the government should have anticipated this sort of black swan event and had laws and regulations in place that would prepare us for the pandemic, rather than expecting for-profit businesses to voluntarily take precautions against something that was completely unpredictable, right? And so, you know, I think COVID-19 has to be laid squarely at the feet of the government rather than, and the government over a period of multiple administrations involving presidents and Congresses of both political parties. I think this was a bipartisan, decades-long failure on the part of our elected leadership.
Yes, Steve, I would say that I agree with you about the government failure. You know, one simple example is, you know, we couldn't, at the beginning of the epidemic, we couldn't get COVID test kits. The reason we couldn't get COVID test kits was that there was one factory in Italy that had a special type of wood that they used to put in the swabs. And that was the only place in the world, all the different companies sourced from this town in Italy, and this town in Italy was hit very hard by COVID, and their factory closed. So it took, what, 3 months or 4 months before companies in the US could gear up and start making these at a higher cost. But it's a government choice. We're going to make sure that that's true next time around, that we're going to have that type of supply. You can't fault, I mean, it also goes back to the carrier example. You can't fault carrier for doing what it did when it looked at all the different numbers and everything else. If the government really felt that strongly about it, there are steps that the government realistically could have taken that would have kept that factory running. And at the end of the day, you know, there are some local cities, local towns or states that are willing to, you know, subsidize either companies to move there or do other things. And part of that is because they want the benefit of the company, you know, workers and taxes and all that. But with some other companies, it may be because they want that type of company in their community, because if there's a crisis or something down the road, that company is going to be there to be helpful. And, you know, it's to the extent that, you know, we talk about the fact that, you know, we used to bemoan the fact that companies had country club boards, that it was the worst thing in the world because there was people, you know, the banker was on the board, the accountant was on the board, the supplier might be on the board. Well, those companies didn't go through these types of issues. You bet that the banker on the board would make sure the company wasn't going to go into default. I'm not saying that we should go back to that, but I'm saying that you really need to have these other interests either somehow come out of the corporate fabric, that people are responsible to it in the boardroom, or it's going to be a government mandate. And unfortunately, the government mandate is going to not get it right.
If I could jump in before Jeff says his piece, I just want to pile on to something David said, which is sometimes we really have to wonder whether the now, 4 or 5 decade push to have majority independent boards, to have boards that, you know, are near 90% independent, and to define independence in a way that gets you people who basically have no working familiarity with the company or the industry, whether that's been an unalloyed good thing. And it has been a burden of my scholarship to argue that you know, maybe we don't want to go back to the days of the country club boards, but that maybe we took the whole independence as a good thing a little too far. But that's definitely a question for another day.
Actually, I don't feel like I am smart enough about healthcare policy to say anything intelligent. My initial reaction is just to tease Steve and suggest that it's not really a problem. It's less a problem of administrations over the last several years and more a problem of the last 8 months. But we can save that for another time as well.
Jeff, you're now an academic, and as an academic, you are by definition smart enough and qualified to opine on anything you choose.
Yeah, well,
your life role.
Yeah, I know it's been 15 years, but there is something. If I can go slightly off in Steve's last statement that I think is interesting, which actually does go to corporate governance and what directors do. Because what I'm hearing Steve say in that last statement is it's more important perhaps than he thought or we thought for directors to be involved in strategy and operations, whereas I have now cited Steve as the person who has said in print that the monitoring function reigns supreme. So to the extent that you have independent board members who in the legal conception are primarily monitors, compliance people, whatever, and not strategists or operational experts, maybe what you're saying, Steve, is we need to rethink that.
Well, if I can put in a little plug for something I wrote with Todd Henderson called Outsourcing the Board.
Yeah.
How board service providers can improve corporate governance. In Outsourcing the Board, we argued that the monitoring role of the board has become the predominant role, but we actually also argue that that's not necessarily a good thing. And that the board's traditional functions of service, of networking, of managing, of advising, are all important board functions that the monitoring model has what's the word I'm looking for? The monitoring model is basically shoved aside. And so descriptively, I think it's true that most of what boards are supposed to do these days is monitoring. But prescriptively, I think that's been a very serious problem in terms of not allowing boards to figure out at this particular company what our best. Thank you, Jim, for putting up the link. I think we've made a mistake by not allowing boards to fit their role to the needs of their specific company.
Well, and Steve, I have read the book, and you and I've talked about this a little bit. I view a board that's quote unquote a compliance board. It's made up of people that focus on the company complying with whatever the regulations are, and they don't have enough time to get to strategy and other things, as a failure of governance. Because that company may be the most compliant in the world, but if it isn't getting the benefit of strategy and thinking about things, and all the board does is focus on compliance, you're going to end up in the wrong place. And there is one other thing that I think people have to take into account. 25 years ago, people served on numerous boards. And so a director who might serve on 4 or 5 boards could see what was working at one company and take it to use at a different company. And that cross-pollination was actually quite a good thing in the boardroom. It's still something that's good with management, but it's resisted today because only CEOs generally sit on boards. But that is a very powerful force. And when you have Sarbanes-Oxley and other things that are saying, no, you don't have the time to do more than 1 board, 2 boards, 3 boards, whatever it is, and people are overboarded, there's a value loss there because you don't have any of that coming in. And I do think that one of the things we need to try to do is figure out other alternatives to provide for that cross-pollination, whether it's allowing CFOs and others to go on boards so they see how different companies operate or something along those lines. I think that's been a big loss, and there's no way to sort of fix it easily.
Can I just jump in, having now given Steve straight lines as an opportunity to sell both his hypothetical and his book? Coincidentally, yesterday, and Jim, you may be able to find this and post this link as well. I posted something on the Columbia Law School Blue Sky blog precisely on this issue, which is that that governance in the conception, in the monitoring conception, doesn't equal leadership. And I agree completely with David from the inside. that if you have a board that's doing nothing but monitoring and compliance, it really is not doing its job.
Well, let me follow up on this discussion by starting with David this time, and David, you could tag the next respondent. We're talking about monitoring, and it's interesting. In Marchand against Barnhill, the Delaware Supreme Court held that the failure of the board of Bluebell Creameries to adopt a monitoring and reporting system, an internal compliance system that would ensure it was informed about risks that were particular to its company, food safety issues, could support a claim, a Caremark claim, based on a failure of oversight. And what I'm wondering is whether you see this as a way to use the monitoring or the compliance, this function, as a judicial means of trying to nudge boards to focus on long-term interests as opposed to the short-term interests of shareholders. And I am making a distinction here, between or among different kinds of shareholders. And so my thought, David, is you've written on oversight. Are the courts trying to nudge boards in the direction of thinking about the long-term with risk management and internal controls?
By definition, they have to be, because you're not going to be looking at risk compliance for something over the next quarter. I think one of the things that's come out of Sarbanes-Oxley and some of the other governance changes is that we focus on trying to put as much risk oversight as possible on a single committee, which is the audit committee, which has a lot of other things to do at the same time. And Leo Strine's written about this, some others have written about this, that maybe it's time for companies to have a committee that focuses on the risks that the company faces. Now, financial services companies already have a mandatory risk committee that's required by the government, but a number of other companies, all the compliance function, all the risk oversight, all that flows into the audit committee. And it either has to come out of the audit committee and go to the board, or it's got to go into another committee, because there's only so much bandwidth directors have. And I think what Marchand was really saying is, you could look at this as a Caremark case, or you can just look at it. You can't run a profitable company if you're going to get your customers sick. And, the fact that the board didn't care about it either from the safety function or frankly from a good business function was very problematic. And the fact that this was going on when it was hardly mentioned in the board's minutes or discussions or other things, it is pretty telling. Now, I dare say that there are a number of other companies that you could go to that would find, similar things, but I think the answer is really to start looking at this from a much broader standpoint and trying to figure out really where this should go in order to have the corporation do well over time. If the company isn't thinking about the ideas that will have risk mitigation, the company is going to be surprised, and it's going to spend more down the road because it didn't deal with the prevention. It's going to look at a cure. And by definition, those things are not going to happen overnight. It's going to take time, but the more we put boards in the crosshairs of, you're going to be responsible for making sure that risks and risk mitigation is undertaken, you have to design the board process to take that into account in an appropriate way. Jeff or Steve?
Again, I like Marchand, and I added it to my syllabus and teach it because to me it's a pure, I teach duty of care as competence. And it seemed to me that what you had was a board that wasn't doing its job for the shareholders. And I have a hard time taking Marchand beyond that conception, which is the board is there to do a job on behalf of the shareholders, among others, to protect the enterprise, and they just failed in the duty of competence. And I don't see any reason why Delaware needs to be the nationwide regulator of the quality of ice cream.
Figuring out what to think about Marchand is kind of hard because it is, in some sense, it's a very shareholder-centric opinion, right? The lesson of Marchand is it's not good for the shareholders if you're killing off your customers. And if you are a basically mono-line business that has as its mission critical responsibility not poisoning your customers with listeria, that the board ought to pay attention to whether or not there's listeria in the ice cream. To me, the more interesting question about Marchand is not shareholder stakeholder. It's the direction of Caremark. My dad was a career Army officer, and he always liked to say, and I'm sure he got this from somewhere, but he always used to say, if it happens once, it's happenstance. If it happens twice, it's a coincidence. If it happens 3 times, it's enemy action. And what we've seen with Caremark over the last year and a half have been at least 3 cases where the courts have at least let a Caremark claim survive a motion to dismiss, which is pretty unusual, right? You prior to the last year and a half, you could, I don't know how many fingers you would have needed to count the number of Caremark claims that survived a motion to dismiss, but it was,
It was less than 1 a year. It was less than 1 a year.
Yeah. And you routinely had Delaware chancellors, Delaware Supreme Court saying Caremark is the most difficult claim in corporate law, blah, 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 blah. And the interesting question is whether we've just had a series of cases with really, really bad facts from the board's perspective, or whether Caremark is starting to grow some teeth. And I think if you read the most recent opinion by I think it was Vice Chancellor Glasscock, I think you still see a certain degree of caution in how the Delaware courts are going to apply Marchand or Caremark rather, but it's an interesting doctrinal question going forward is whether this is just a weird coincidence of bad fact cases, or whether really Caremark is growing teeth.
And Steve, to answer that, I would say I don't think Caremark is growing teeth, but Caremark is at least waking up to the fact that boards need to be monitors as well as have other jobs, and any board that sort of turns a blind eye to it or a knowing blind eye to it is really at risk. I think that what's going to happen is boards are going to try to better understand what some of these risks are. And frankly, it should flow through, with a new principle-based disclosure that the SEC is putting in SK. I think you're actually going to see that help the board attack these issues a little bit better. But, perhaps I'm too much of an optimist.
I always worry about the availability heuristic when we're looking at 3 cases and trying to make a broad generalization. I worried about that 20 years ago when it was Enron and WorldCom and Tyco, and there were 9,000 public company boards, and we got to assume that every board was as corrupt as those based on the availability of the information. So I'm inclined to think, Steve, that bad facts will always make bad cases.
We now have a little more than 10 minutes for audience questions. Some of them have filtered in already. I'll try to summarize a few of them just right off the bat. If you have additional questions, feel free to type them in the chat to everyone. The first set of questions relates to who is a stakeholder, which stakeholders matter, and a related question is how do we measure if we're benefiting stakeholders? A second question pointed to the Business Roundtable statement on climate change and encouraged lobbying for efforts to address climate change. Can we distinguish between general lobbying by groups of CEOs and individual decisions by CEOs? And then finally, there's a comment about how the way funds are organized, the staffs that are working on ESG are not voting on investment decisions, and doesn't that support the argument that this is cheap talk? And so whoever, you can answer all of them to the extent that you're.
Let me try putting some of those questions into a practical perspective, and I sometimes wear my academic hat, but I try to not to all the time. You know, anybody can claim they're a stakeholder. One of the big issues you have with ESG is until we come up with some way to measure ESG, you're going to have people all over the place because there's going to be no consistency, there's going to be no comparison, and it's not an easy thing to measure. It's not much different than saying who is a stakeholder. In some companies, for example, the suppliers may be a stakeholder. In others, it may be the customers. But is a customer really the stakeholder if it's a retail company and the only way the company does well is if its customers buy its products? It doesn't really make them a stakeholder as such. You know, I do think that we are going to figure out some ways to monitor ESG. There's a couple of competing systems out there. We have to get down to you know, something that really works, and some funds have come out on the side of particular measures. But until you do that, I think it's going to be very, very difficult. Jeff or Steve?
I'm not sure that the question about stakeholder, what underlies it isn't really a question about legal standing. Because again, where I come from, nuanced decisions about the allocation of time and resources within the enterprise is what managers and boards do every day, boards less so. And you know, one of the questions that got posed to us was, you know, how should a board make a decision? How should you consider situations where the interests of stakeholders conflict? And because we're always talking about limited resources, invariably, somebody's on board, and so make decisions with respect to the community as a whole. And when I say the community, I mean the entire enterprise and anybody who is benefited or harmed by it. That's what we do. And so I guess I'm less concerned about who has legal standing to complain about that, and more concerned about the quality of the decision making, at least as a business matter.
Yeah, I think a broad agreement.
Jim, any other questions?
None are popping up in the screen at the moment. We have about 5 minutes. I guess one question I had for
Jim, I see.
Oh, Iman, go ahead.
I see.
Oh, do you see one?
Yes. Saul?
Could you go? Oh, I see. Why would we trust CEOs or boards to know what is in the best interest of their community or society? Are proponents of ESG really okay if a board determines it's in the best interest of their stakeholders to support any issues?
Well, let me try and answer that, because I think this does go back to Keith Bishop's question about who's a stakeholder. I think that when we talk about ESG issues and stakeholder issues, we're most of the time talking about the impact of corporate decisions on employees. Not always. Sometimes we are concerned about communities, creditors, customers, suppliers, but I think most of the time we're concerned about, you know, we're talking about the impact of a decision on employees. And I do trust boards of directors to have a pretty good sense of, you know, what's in their employees' interests. I mean, after all, the only way shareholders make money is if employees are productive in generating goods and services that people want to buy. And so shareholders obviously have an interest in how the company treats its employees. I remember visiting the Anheuser-Busch brewery in St. Louis once, and it's an enormous complex, and they were saying, you know, this is our employee health clinic where our employees can get, you know, health care. And this is our employee credit union where our employees can get, you know, loans and credit and checking accounts and credit cards and so on. And there were a lot of facilities at this complex that were designed to benefit, to improve the life of their company's workers. And you know, even back to Dodge versus Ford Motor Company, the court said in that case that it's okay to have these sort of incidental expenditures for the benefit of your employees. So now I think, you know, it's when we start talking about boards, you know, do we want boards staking out positions on climate change, those sort of questions, where, you know, I'm less confident that we want board members, you know, making decisions. But again, you know, it's you can imagine situations where a company would say, take Tesla for example, we want to go in hard on being supportive of efforts to deal with climate change because basically it creates a halo around our product. So, you know, again, it comes back to the fact that in non-zero sum decision situations, the reason we have boards is precisely so that boards can exercise discretion with respect to these sort of cases.
Let me just jump in. I remember vividly 1997, 1998, and 1999, and I believe the SEC required disclosures on Y2K compliance. Yep. And at least that struck me as directly related to the health of the organization. I'm not sure about the climate change stuff and required disclosures, but you know, my reaction to it is that again, other institutions weigh in, and you know, corporations live as citizens in a political world, and it may well be that that's what you have to do. But again, I do recall all of the disclosures that had to be made on your Y2K compliance. And I'll simply say that in our company, we expected that Italy was going to completely implode and shut down, but it seemed to survive. So maybe that's hopeful.
I guess the one point I would make here is I think that it's different to have a corporation supporting a politician than perhaps a corporation supporting a political issue or a non-political issue. And, you know, when you get to those types of matters, I mean, is JP Morgan benefited by Jamie Dimon saying that, you know, climate change is real? It could argue that maybe it's helping, you know, deal with some of the mortgages and some of its customers and others. But at the end of the day, there are going to be global issues that if CEOs don't weigh in on, I think that they're almost going to be negligent because their outcome could have a huge impact on the country. But is there a required obligation to do that? I can't say that there is.
It looks like we have come to the end of our panel. I wanted to say thank you to the panelists and our audience for a great event. And also I wanted to highlight that the next panel in our conference will be in a few weeks on Friday, October 9th, 12:15 Pacific. It will be on COVID's effect on restructuring, bankruptcy, and finance. Aman and Joel, any final words?
I just thought this was a really substantive discussion, and we got into some of the difficult issues, which we did not gloss over, and I really appreciate that and want to thank the panel for engaging.
Yes, thank you to the panel. Thanks to Ahmad and Jim, and thanks everyone for attending. We appreciate it. See
Thank
you
you.
next time.
Take care.
Bye,
Bye-bye.
everyone.